Good day, my unique students. I hope you are having a tremendous moment at home with your parents. This is your civic education teacher, Mr. Amanam Igbe. You are welcome to this e-teaching and learning process. It is going to be very, very interesting, and I want you to be attentive. Today, we are going to look at the topic Constitution. Please, don't forget that we started this topic last time, and we are going to conclude it today. In today's lesson, we have two subheadings that we are going to discuss: the sources of the Nigerian Constitution and the features of the Nigerian Constitution. Before I swim into action, I want to remind you what I taught you concerning Constitution last time. I told you that Constitution is a set of rules and regulations that guide and coordinate the behavior of people in the society. And I made it emphatically clear that there is no country without a constitution, because a constitution is an instrument put in place by the state to regulate, organize, and coordinate the behavior of everybody in the society or in that particular state. We are referring to the government and the citizens. So there must be laws, there must be rules and regulations put in place in order to organize and regulate everything in the society. So those rules and regulations is known as the Constitution. And we also discussed the classifications of the Nigerian Constitution. And I told you we have four classifications of the Nigerian Constitution. We have the flexible Constitution, we have the rigid Constitution, we have the written Constitution, and we have the unwritten Constitution. And I told you that a written Constitution is a constitution or is a rule that has to do with a situation whereby all the laws are written down in a single document. A written constitution can be defined as the rules and regulations that are codified in a single document. On the other hand, the unwritten constitution means the constitution whereby all the rules and regulations are not codified or are not documented in a single document. A rigid constitution is a constitution that cannot be amended, or the procedure that would have led to its amendment is too cumbersome. Too cumbersome means it is too difficult. And I also told you that a flexible constitution is a constitution that can easily be amended. In addition, we discussed a series of constitutional developments in Nigeria, starting from the 1914 Nigerian Council to the 1922 Clifford Constitution. Please, my students, don't forget this. From the Clifford Constitution of 1922, we have the Richards Constitution of 1946. Then we have the Masterson Constitution of 1951. Later, we have the Littleton Constitution of 1954. Then the 1960 Independence Constitution. We have the 1963 Republican Constitution. We have the 1979 Presidential Constitution. We have the 1983 Nigerian Constitution, and we have the 1999 Constitution of the Federal Republic of Nigeria. Please don't forget the series of constitutional developments in Nigeria. Today we are going to look at the sources of the Nigerian Constitution. Number one is legislation. Legislation. These are bills passed into law by members of the legislative arm of government. What is a bill? A bill is a proposed law that is not yet a law. A bill can only become a law when it is passed by members of the legislative arm of government. Don't forget, the primary function of the legislative arm of government is lawmaking. So legislation is one of the sources of the Nigerian constitution. Those laws made by the legislative arm of government forms part of the Nigerian constitution. Number 2 is customs and conventions. Don't forget, in Nigeria, we have customs, we have conventions. We use them interchangeably. Customs and conventions are those way of life, the acceptable behavior, attitude, or the manner through which things are done, the pattern of doing things in a given society. And this is used as a criteria during the drafting of the constitution. Our customs is used in designing and organizing the constitution of Nigeria. So constitution are also derived from customs and conventions which are strictly obeyed in the society. Those values, those norms in a given society forms part of the constitution. My students, hope you are listening. Number 3 is judicial president. Judicial president. What we mean by judicial president means the judgment given by the judicial arm of government is used as a tool or is used during the drafting of the constitution. You know, the judicial arm of government is an arm of government that is saddled with the responsibility of interpreting the laws. The manner and pattern through which the laws are interpreted by the judicial arm of government serves as a yardstick to the legislative arm of government, and some of these judgments are used to form part of the Nigerian constitution. It is even used as a guide during the formation of the Nigerian constitution. Number 4, we have constitutional conferences. We have in fact, before the 1954 Littleton Constitution was put in place, don't forget that was the constitution that introduced formally federalism into the Nigerian political system. There were 2 constitutional conferences. The first one was in 1953. It was called the 1953 London Constitutional Conference, whereby representatives were sent to London to discuss with the Secretary for the Colonies ways or measures that should be put in the new or in the proposed constitution. So representatives went to London during the colonial period to play a very active role in the conference that was organized in London. When they came back, they had another conference in 1954, and that was known as the Lagos Constitutional Conference. It was to summarize what was discussed at London. Then a constitution was put in place that was known as the Littleton Constitution of Nigeria that was used. And one of the discussions in London and even in Lagos in the conference was that Nigeria needs a federal system of government. And the 1954 Littleton Constitution stipulated a federal system of government in the constitution. That shows that constitutional conference is one of the sources of the Nigerian constitution. In fact, if we want to amend the present Nigerian constitution today, there is going to be series of conferences, seminars, or workshops so that professionals, citizens, and other people that are well inclined in this context will come together, sit in a round table, and discuss how the Nigerian constitution is to be drafted. Number 5, my students, please pay attention and listen, is international laws. What we mean by international laws? They are universal laws, the laws that guides the behavior of everybody in the country, the behavior of political actors, head of states, presidents in a given country. And these laws forms part of the constitution of a given nation. For example, we have the Universal Declaration of Human Rights that was stipulated by the United Nations General Assembly on December 10, 1948 in Paris. The United Nations made it emphatically clear that there is need for human rights to be stipulated in the Constitution of Nations. You know, human rights is very important. Without human rights, life becomes unpleasant. So in that case, countries of the world, governments in all the nations were encouraged and advised to stipulate this particular law in their respective constitution. And we also have another law, just like the laws on International Civil Aviation Convention, the laws that regulate the behavior and activity in this particular transportation, activity. It is the aviation, the movement of people in air transportation and so on. So the international laws put in place by the United Nations General Assembly forms part of our constitution. Number 6 is decrees. These are the laws made by the military system of government. And most of the rules in our present Nigerian constitutions were made by the military system of government. Though some people are criticizing the present Nigerian constitution based on the fact that it was made by the military system of government. They said the military system of government was undemocratic, and as such, Nigerians were not consulted during the drafting of the constitution. But as it stands now, some of the decrees, promulgations made by the military during their regime forms part of our constitution. My dear students, let me remind you that the 36 states that we have in the Nigerian Federation, those states were created by military system of government back then in Nigeria. No state was created by a civilian government. So, irrespective of the fact that the military system of government is criticized, they played a very significant role in designing the Constitution of the Federal Republic of Nigeria. So decrees, don't forget, decrees are laws made by the military system of government. If you check the past questions in your junior NECO examination, you see questions on constitution laws made by the military is known as, please don't forget, it is known as what? Decrees. Number 7 is past experience. Past experience. We had a colonial experience with the British. The British were our colonial masters. What we mean by colonial masters means that they were the one that came and colonized us. You've heard of colonialism, and I believe you've heard a story whereby the British came and dominated and controlled our political system. That process was known as what? Colonialism, the political control and domination of the Nigerian territory. That was what the British came here to do to the Nigerians. They colonized us. They took absolute control of our political system, even our economic system. So our past experience with the colonial masters as regards their policies, even the institutions they put in place, the rules and regulations, those structures, even when we had independence, serves as a tool, a guideline in the drafting of the Nigerian Constitution. And the Nigerian Constitution was modeled according to the British Constitution. Don't forget, for instance, they introduced a parliamentary system of government in Nigeria, and we had practiced a parliamentary system of government in Nigeria. So this is what we mean by past experience as a source of the Nigerian Constitution. Now, in the second subheading, we have the features of the Nigerian Constitution. Features can also be known as characteristics, can also be known as features or qualities or attributes. Number one is title. Every book has a title. In the Nigerian Constitution, if you have a copy, and I told you that every family, as far as you are a Nigerian, you are entitled to a copy of the Nigerian Constitution. The same way a Bible is important in a home, that is the same way a copy of the Nigerian Constitution is very, very necessary. So I told you to find out from your parents if there is a copy of the Constitution of the Federal Republic of Nigeria. The reason is because it is very, very imperative for students and adults to know the content of the Nigerian Constitution, so that when your right or when a particular rule or regulation is violated, you can make reference to a particular section of the Constitution for clarifications, and it's going to enlighten you as a Nigerian. And as a student, you need a copy, and when you come back to school, I'm going to check. Please try as much as possible to have your own copy. Now we are going to look at number one feature. You have a title. Every book has a title. So the title of the Nigerian Constitution reads Constitution of the Federal Republic of Nigeria 1999. If you have seen, it is green and white. Now it is a feature of the Nigerian Constitution because the title gives you an idea of what the content of that book is all about. So it serves as a characteristic. Number two is preamble. Preamble is the introduction to the Constitution. It defines the spirit, the unanimous agreement reached by Nigerians in the drafting of the Constitution. It shows that Nigerians have accepted the content of the Constitution. The preamble tries to clarify the spirit, the agreement reached and accepted by Nigerians in the drafting of the Constitution, and as such, it indicates legitimacy and acceptability and recognition. So the preamble is the introduction of the Constitution, and it explains the spirit upon which the 1999 Constitution was written. Number three, organs of government and agencies of government and their areas of specialization are defined by the Constitution. One of the characteristics or features of the Nigerian Constitution is that it clarifies the three arms of government. Please don't be confused about the arms and levels of government. The arms of government can also be known as the organs of government or the branches of government, or the institutions of government, or the structures of government. They are the legislature, the executive, and the judiciary. Please take note. While the levels of government can also be known as what? The tiers of government, or the component units of government. There are the federal level of government, the state level of government, and the local level of government. Now, one of the features of the Nigerian Constitution, as we guide that number 3, is that the organs of government is well stated, and their functions as regards separation of powers is also clarified in the Constitution. We have 3 organs of government, and these organs of government are the institutions put in place by the state to organize, administer, and regulate the activities in the state. For instance, the legislature makes the law, the executive enforces the law, the judiciary interprets the laws. And when we talk about the agencies of government, we are referring to, for example, the National Drug Law Enforcement Agency, the Economic and Financial Crime Commission, the Nigerian Port Authority. We have the Nigerian Police, we have the Nigerian Army and other agencies. We have the ministries, we have the other institutions of government and so on, that have one function or the other to perform in creating an enabling environment for the smooth running of the society, for the smooth running of the government. So all these functions are defined and assigned to these arms of government, as well as the agencies of government put in place. And some of the agencies of government are established by an act of parliament. So it is well clear that one of the features of the Nigerian Constitution is that it made provision for the establishment of the arms of government and agencies of government, and the relationship between these agencies, institutions, and arms of government are well defined and well coordinated in the Constitution. Number 4, we have fundamental human rights. Fundamental human rights is very, very important, and as such, in order to protect these rights from violation, it is written, or it is enshrined in the Constitution of the Federal Republic of Nigeria. And the punishment attached for violators is also clarified. So in the Nigerian constitutions, we have the fundamental human rights that needs to be obeyed, that needs to be protected and guaranteed by the states. And there are punishments for those that violate these rights. That is why it is very necessary for you to have a copy of the Nigerian constitution, so that you can make reference to it whenever your right is abused, or whenever the right of some other person around you is abused, or when somebody is ignorant about the content of the Nigerian constitution. You can use it to enlighten the people. Number 5 is amendments. The constitution provides a procedure for amendments, what needs to be done, the criteria, what should be put in place in order to make the amendment possible. You know, Nigerian constitution is written and rigid. So in this context, if there is need for it to be amended, we are in a dynamic society. The world is changing, and as such, there is need for the constitution to be amended in order to suit the contemporary issues or the major issues in the society. So if there is need, or whenever there is need for amendments, the constitution will be referred to. People will make, or the professionals, maybe the legislative arm of government or any organization, sorry about that, will make reference to the Nigerian constitution to see if there is need for the amendment of the constitution to take place. Number 6 is sharing of powers between the 3 levels and arms of government. This is when we talk about sharing of powers between the 3 levels of government. We talk about federalism. Federalism defines the sharing of powers among the 3 levels of government. In definition, federalism is a system of government or is identified with power sharing among the three levels of government. That is the federal level of government, the state level of government, and the local level of government. And functions that are meant for the federal level of government is in a list known as the exclusive legislative list. The federal government perform functions under the exclusive legislative list. That is functions on currency, functions on immigration and customs, functions on national security, functions on external affairs, and so on. Those functions are in the exclusive legislative list. So the Constitution tries to specify the functions that are meant for the federal level of government. The state level of government perform functions on the concurrent legislative list that has to do with education, agriculture, transportation, and so on. But the federal government can also perform some functions under this concurrent legislative list. In fact, both the federal and state government perform functions collectively in the concurrent legislative list, while the residual legislative list is meant for the local government administration. Now, coming to the arms of government, we have what is called checks and balances, checks and balances and separation of powers. The Constitution also tries to separate the powers of the three arms of government, are separated both in function and in personnel. The governor, the ministers, the commissioners are under the executive arm of government. Their function is to enforce the law, plan and implement government policies. The judiciary is to interpret the laws. They are the judges, the magistrates, lawyers, and so on. While the legislative arm of government, they are saddled with the responsibility of lawmaking. So one of the characteristics of the Nigerian Constitution is that there is a clear definition of the activities and functions of the three arms of government. Hope you are listening. You are listening. You can pause to write the note accordingly, please. Number 7 is the tenure of office. The tenure of a given administration, or the tenure of a political office holder, is defined by the Nigerian Constitution. This is to avoid sit-tight leaders. That is why you will not have a government that is established, or you will not have a democratically elected government that comes into power and stays for too long. There is a limited period of time. The Constitution tries to put in place the number of years, the tenure of office of a particular office holder. For example, the president cannot exceed 2 terms. That is 8 years. The same thing with the governor. So the tenure of office, the Constitution states the number of years a government will stay in power. That is the end of the lesson. That is the end of today's lesson. And please, before I summarize what I've taught today, I want you to understand the sources of the Nigerian Constitution. Know the sources where the Nigerian Constitution is gotten from past experience, from decrees, constitutional conferences, and also know the features of the Nigerian Constitution. That is the tenure of office, power sharing, the title, the preamble, the arms of government, and so on. Please, I want to encourage you to read. Go through the past questions. Try to check questions from Constitution. Answer them. Read and try as much as possible to cover all the past questions, so that in your junior NECO that is coming up, you will be able to attempt all the questions constructively. Thank you very much for giving me your attention. Bye for now.